Hello and welcome to today's webinar. I'm Beth Holly with the Arizona Association of Realtors, and we're proud to bring you these free broker brief webinars designed exclusively to keep you updated on issues in the industry and AAR activities. Today's webinar will be an open forum where legal experts, AAR CEO, and AAR General Counsel will answer your previously submitted questions and touch on today's hot topics. Joining us today is Michelle Lind, CEO of AAR, Scott Drucker, AAR General Counsel, Jesi Wolnik, Associate Attorney with Manning & Cass, and Denise Holliday, Landlord-Tenant Attorney with Holliday & Holliday. Today's presentation will be about 45 minutes long. If you have any questions during the webinar, please write into the question box and we will try to get them answered at the conclusion. As always, today's webinar will be recorded and available next week on our website at AAR Online. So welcome and let's get started. Michelle, what's new at AAR?
Thanks, Beth, and good afternoon, everyone. I just wanted to go over a few issues that we're working on at AAR that would be interested for the brokers and brokers that are participating today. The first issue is the use of out-of-date forms continues to be an issue. So please remind your agents to make sure they're always using the most current version of the form. Agents get out-of-date forms when they reuse a zip form transaction. So they need to open a new transaction each time. We have been working with zip forms on this issue, and we will be implementing a feature that should reduce the number of out-of-state forms being used. This feature is a pop-up. So if the agent tries to use an out-of-date form, they'll receive a pop-up letting them know that this is an out-of-date form. However, they can still bypass it and use the forms. So please do remind your agents to be vigilant and not to use those out-of-date forms. Speaking of forms, you may be aware that AAR has been licensing these forms to for a fee to some vendors on their online software platforms. The vendors have to meet certain criteria set in place to ensure the integrity of forms and ensure the forms can be accessed only by members. In July, AAR will begin offering brokers the opportunity to license AAR forms at no additional cost, assuming they comply with the criteria. If you're interested in licensing the AAR forms, please contact Nick Catanese here at the association. I also want you to please try to remember to talk to your agents about AAR's Tech helpline. The Tech helpline is available to fix virtually any computer, tablet, smartphone, digital camera, DVD, network adapter, printer, and any other device. They have expert computer analysts. They're US-based. They know the real estate industry, and they're highly qualified. We have had nothing but excellent response to the assistance that they're able to provide. So if you or one of your agents have an issue with your computer or other device, go to AAR Online and look under Business Tools or search Tech Helpline. I guess the final issue that I wanted to talk to you about today is to let you know that your investments in RAPAC have been critical in our ability to protect realtor and homeowners' interests at every level of government. You may know we just got back from Washington, D.C. meetings in May, where we met with our members of Congress and talked about tax reform issues and preserving the mortgage interest deduction, the critical necessity for the National Flood Insurance Program to be extended and modernized, and protecting 1031 exchanges to support a robust investment market. We're also been heavily involved at the state level, at the governor's office, at the legislature, at the Department of Real Estate, and at the Corporation Commission. in fact, we've been so effective that we've earned 2 nominations for the Best of Capital Awards, so we're pretty excited about that. Our successes are 100% of our bills were passed by the legislature. We got a new statute, and Scott Drucker worked diligently with the Department of Real Estate in crafting a new substantive policy statement that I'm sure you heard about that clarifies the tasks that may be performed by an unlicensed assistant. We also expanded the exemption for mobile home agents to be able to sell a mobile home under certain criteria. So if any of your agents do mobile or manufactured home, again, go to AAR online and you can find out about the additional extension. We have also been hearing a lot from members around the state about heavy-handed sign ordinances as a result of the U.S. Supreme Court case that arose from a Gilbert, Arizona sign ordinance. And a lot of municipalities are revising their sign codes, and we've been working with the local associations to ensure that those revisions don't adversely affect real estate or open house signs. And because we've seen so many of these popping up issues around the state, we applied for the National Association of Realtors for a grant to retain a national constitutional law firm to research whether, given the U.S. Supreme Court case, we can address these sign ordinances at a state level at the legislature. And just one more thing, mark your calendars. The broker involvement reception, we're having a broker involvement reception the evening of September 6th at the Phoenix Marriott Tempe at the Buttes. We'll have network opportunities along with a short presentation on how to retain your agents by creating a culture of advocacy within your brokerage firm. So look for your email to come with that invitation or contact Charles here at AAR. So Beth, that's just kind of a summary of some of the things we're addressing here at the association.
That's it? Gosh, that's a lot.
That's okay, Scott. Here's your turn.
Okay.
So talk to us about copyright infringement issues and the new SPS ADRE issued regarding unlicensed assistants.
Sure. Thank you, Beth, and good afternoon, everybody. One of the things Michelle mentioned was the NAR convention that recently took place in May, and from a risk management perspective and all of the risk management meetings, one of the very hot topics was copyrights and copyright infringement. And so I wanted just to quickly touch on a few points in regard to those topics. As you probably know, a copyright is a form of protection for original works that exist in some physical form. So you can't copyright facts, right, because a fact isn't an original work. You can't copyright an idea. Something pops in your head, well, that's not in a physical form. So those are the sorts of things that are not subject to copyrights. And a misconception, that we frequently hear about copyrights is that, oh, if I want to copyright, I've got to register something with the United States Copyright Office, and that's actually not the case. An original work is subject to copyright protection the moment it's created in some tangible form. So picture yourself taking a photograph, right? The second you snap that photograph, the picture itself the photograph is copyrighted, and whoever took the picture, if you are the one that snapped that photograph, well, you own the copyright. So let's apply all of this to real estate listings, because that's really where it pertains to us. When you think about a real estate listing, and a listing has some original content, right? Photographs of the property, drawings, maybe creative remarks about the property or the neighborhood itself. All of that is eligible for protection under copyright law. Therefore, if you copy that type of content without a license, which is essentially permission from the owner, that could constitute infringement. And where we see this the most is with a listing agent who's taking over the listing from a prior agent. And in this scenario, the new listing agent has to remember that they don't own the prior listing content, and they can't use it without permission. And remember that it's not always the homeowner that owns the copyright. If the prior agent was the one that took the photos, well, the prior agent owns those photographs. If a professional photographer took the photos, well, the professional photographer owns it. Sometimes we see agents that want to copy and paste the listing content, you know, the descriptions, and some of them are quite creative. That was likely written by the prior agent, and so the prior agent is the one that owns that information, and you would need permission to reuse those photos or that text. If you want more information about copyrights, on June 2nd, we published on AAR's blog some copyright FAQs, right, frequently asked questions, which were also published in The Voice, and you can find all of that on AAR's website. Before I give up the microphone, I did just want to touch on another topic that Michelle mentioned, which is the fact that on June 9th, ADRE did in fact issue a new substantive policy statement regarding unlicensed assistants. The SPS is numbered 2017.01, and it replaces the old SPS, which was 2005.04, and so that was essentially, what, 12 years old, and it had grown stale. It didn't necessarily reflect everything that unlicensed assistants can and should be able to do in today's marketplace. So we worked with ADRE, and we're very pleased that the new SPS was released. There's a lot in there. If you haven't read it, you might want to take a look at it, but two of the things that I like about the SPS is, number one, that it emphasizes that unlicensed assistants can be hired by salespersons. It seems obvious, but I'd like to have it in writing because every once in a while you'd hear something to the contrary. Also, it clarifies that employing brokers are responsible for all activities of licensed individuals within the brokerage, which again is a point of clarification that I thought was necessary. If you want to take a look at the SPS, it's on ADRE's website, and it was also in this week's edition of The Voice. Thank you.
Thanks, Scott. So Jesi, what is happening with advertising with nicknames?
So on the hotline, I will frequently get calls regarding various questions, and within the question, I'll realize sometimes I see a name that isn't the same as what they may be licensed under, and a common example is Michael, and they use the name Mike instead. And so as a courtesy, I'll often mention it, hey, are you aware of this? And so it's something that I frequently mention, and I just continue to put out the information because I think a lot of individuals aren't clear on the department's position. And so I just wanted to remind everybody that there is a commissioner's rule, which is 28-302, Section I. That commissioner's rule says that an individual cannot conduct or promote business under any name other than the name under which the person is licensed. And so a perfect example is if your Facebook page says Mike Smith instead of Michael, or Jan Smith instead of Janet, and the department would say that is a nickname. In order to be in compliance with the commissioner's rule, they have a form, LI 235. You can get it from the department's website, submit it, and now you have a registered nickname. However, be aware, for those of you who have used the nickname form, and it's been many years, and at the time I don't think the department was providing this guidance, or maybe you had forgotten if you received it, but when you submit your form, LI 235, the department responds back, acknowledges they've received it, your nickname is registered, and they give you an example of how you may then advertise with your nickname. And it seems to be the prevailing rule. The example they give is with Commissioner Lowe's name. They show Judith, quote, Judy, end quote, Lowe, or quote, Judy, end quote, Judith Lowe. So the guideline is, even if your nickname is approved, you should, to be safe as a best business practice, not be using your nickname alone, because they're giving the example of always using the quote. I've heard different feedback from different brokers who had said they received various information, and so I'm just letting everybody know what the department's guideline is when they send back that accepted LI 235.
So just for clarification, social media is advertising. So
Absolutely, yeah.
Facebook,
yeah.
LinkedIn, all of those channels, they should file that.
If you send an email to somebody as their realtor, and it says, you know, Mike Smith, it should still comply with the nickname guideline with Mike in quotes.
Great, thanks for the clarification.
Mm-hmm.
So Denise, assistive animals is a hot button property management topic right now. Any thoughts? Also, what is the latest news on 88 parking lawsuits?
Okay, so let's start with the ADA parking lawsuits first. It's a great news. There were about 1,800 lawsuits filed. One judge took jurisdiction of all of the cases. They have found that they were filed for improper purposes. So they are now allowing the defendants to submit the request for attorney's fees on all of those cases. The plaintiff was one single nonprofit who has since changed legal counsel. The original legal counsel has some issues in front of the state bar that they're addressing. They also recently, thank goodness to you guys and the legislature, we passed a bill signed by the governor that said, as at least to Arizona fair housing laws or ADA laws, a person who is a complainant who believes that the parking or any ADA issue is on a property, they have to give a written 30-day notice to allow that business owner to fix the issue. If you weren't aware of that particular case, they were using Google Maps, and they were looking at commercial properties and residential properties, mostly apartment communities, and wanting $5,000 or $10,000. Not really caring if you ever fixed the sign issue to begin with. So it was how wide your parking spot was, your ADA parking spots. Did you have a side? Some of them have to be van accessible. All the cities have different rules and codes. So the good news is they recognize that no one wants to be in violation. They just weren't sure that they didn't know the laws changed. And so there's a new law that says you have to be on notice, a written 30-day notice, before they can file any kind of lawsuit. So kudos for everybody who worked hard on that. That was terrific. The other issue about assistive animals, it is continuing to be a problem. There is no state or federal law that defines a lot of those issues. What kind of training does the animal have to have? Exactly what disabilities qualify? How can we verify this is a real doctor that's really seen this person who's quote-unquote a medical provider? There continues to be lots of abuse of that particular law. California is actually the first state that has decided they're going to address it in the state courts, which we find interesting because federal law trumps state law always. But they've had such a big problem in California that they're attempting to come up with some reasonable restrictions that property owners on the ADA side, so the public areas which deal with service animals, and the residential side, which is the fair housing side, can ask what kinds of information, restrictions on the animal, whether they can be puppies, how many you can have, what about if insurance carriers won't insure the breed, lots of different issues. And so we're going to watch California and see where it goes. Arizona, the different stakeholders have looked at that. We're just not sure that the feds won't slap it down. And so we're waiting to see if another state is going to spend the political capital and the financial capital to run any of those bills. And that's really where we are. The biggest thing for anybody who's a broker is you need a policy that all of your agents are aware of and your unlicensed people, because it's the comments that they make over the phone that are typically what I see in the fair housing violations filed with one of the enforcement agencies.
Great, thanks for that information. So let's get to the questions our viewers submitted. Michelle, what are your thoughts on Zillow Instant Offers?
Zillow Instant Offers, it's been big in the news, obviously. It's a new business model, and we see new business models coming out we have for years. Everyone's trying something. My understanding is this is a pilot test. It's only in 2 markets, Orlando and Las Vegas. And what they do is they offer to sellers to get all cash offers. These cash offers come from I guess they have about 15 large private investors. The investors are either licensed as a broker or are using a third-party broker. And my understanding, the offers are managed by .loop, and then Zillow Premier agents are looped in to prepare CMAs. So that's the general model. As far as organized real estate, as the National Association of Realtors or the Arizona Association of Realtors, we recognize that real estate's a competitive business. Everyone's tries new business models. Some succeed and some fail. But we can't encourage any kind of boycott, or it would be absolutely unlawful. It would be an antitrust violation to discourage members from using any product or service provider like Zillow. But what we can do and what we are doing is continuing to provide information to the consumers about the value that a realtor brings to the transaction. And that's what I believe the industry needs to focus on, is that message, that realtors bring more than just an MLS information, that they guide their clients through one of the most difficult transactions that they will ever have in their lifetime. So that's what I think our emphasis is, and I think that's what the industry's emphasis should be.
And those campaigns are taking place both on a national and local level, correct?
That's absolutely right. On a national level, you'll see a lot of them. Thanks, Scott. And then on the state level, we work. We have a public relations firm that we work with to consistently try to get that message out to the consumers.
Thank you. Scott, what are best practices for final walkthrough disputes?
Sure. My favorite way to answer a question is to say, we have a form for that. And in this case, I'm happy to say we have a form for that. And I know that every situation's different, but the form I'm referring to is the buyer's pre-closing walkthrough. And it essentially provides the buyer with two choices after they conduct their final walkthrough. The first choice is just where the buyer acknowledges that, hey, property looks good. The repairs were made, the corrections were made, I'm satisfied, I'm moving forward. That's the good box. The second box is where the buyer notes that some or all of the corrections and the repairs haven't been made or haven't been made to their satisfaction. And it's at that point where the form actually acts as a 3-day cure notice. Hopefully, by the end of that 3-day period, the seller goes ahead and makes those repairs and the transaction proceeds to close escrow. But of course, that's not in every case. That doesn't happen always. Fortunately, in most cases, the breach is relatively minor. And when I say it's minor, I mean that it's not a sufficient reason to walk from the contract and fail to close escrow. And so really the remedy there is, when the breach is minor, is in fact to close escrow. And then if you want, you can pursue the damages in small claims court after close of escrow. Now, there may be some cases in which the breach is so significant that the buyer may not want to close escrow, and that would be their right, and they would have the ability to submit a claim for the earnest money in those circumstances. But I would caution you that the breach has to be substantial. If the breach is insignificant, as I said, that's not going to be a reason to walk away from the property entirely, and because you may then find yourself in breach of the purchase contract. But either way, as a last point here, just make sure that if you've got a client in this situation, that you're encouraging them to speak with legal counsel and you're not the one giving them the legal advice on how to proceed.
John just posted a question. The question is, when the parties disagree on whether or not there is a breach, how do you handle that?
That's a good question, and ultimately you hope that the parties are going to put their heads together and compromise. But if push comes to shove, it's a question of fact, and that's something that's ultimately going to be decided by a court of law. And when you get to that point, as the judge in the room will tell you, you may have everybody in a losing position, and so it's going to really benefit the parties to reach a compromise and to make whatever that repair is, which hopefully will solve the issue and allow the parties to both proceed to close of escrow.
And if I can add, this is Jesi. Of course, on the hotline, we're always trying to counsel regarding risk management, and those of you who've spoken with me know my counsel always includes to protect yourselves as brokers from giving advice that somebody may disagree with. You can always advise them to consult an attorney, the buyer or seller who's potentially trying to cancel that may be improper and cause them subject to litigation as well.
Thank you all. So Jesi, I heard a little bit of talk about a new manufactured homes rule. What is that?
Yes, so as Michelle mentioned, there was House Bill 2072, which amends Arizona Revised Statutes 41-4028, and that is going to allow the sale of manufactured homes and mobile homes that are located in mobile home parks. You can find the House bill on the internet, and I understand the bill was signed in March. I saw that there was a notice that legislature ended May 10th, and typically those bills that were passed go into effect within 90 days from the end of the legislative session. So somewhere around the first week of August, it should be in place. Again, there are 2 paragraphs or 2 sections added to that statute. Again, that a licensed real estate agent can sell new or used manufactured homes and mobile homes that are located in home parks if number 1, the licensed real estate broker or real estate salesman is acting as an agent for a licensed housing dealer. And there's additional language, but that's the gist of it. And then number 2, or a licensed real estate agent can sell used manufactured homes and mobile homes that are located in mobile home parks if they are licensed under a real estate broker. So in essence, if you have a real estate license, you should be able to sell a manufactured or mobile home that is within a park. There are rules and exceptions, of course. We are actually working with my firm, Manning & Cass. We are working with the Manufactured Home Association to help draft that contract, and there is a warning reminding the buyer purchasing the manufactured home or mobile home that they still would have to enter into a separate lease agreement with the park. So there are things to be aware of. There will be a lot of new and exciting changes, but that bill did pass.
And I want to just add to it, because we get the question here at AAR, well, is there a form? Now I'm going to be selling a mobile home. It's like selling a car, right? There's no land necessarily involved in that transaction. Is there a form for that? And the answer is we don't have any forms for the sale exclusively of personal property. But as Jesi mentioned, the Arizona Manufactured Housing Communities Association is working with Manning & Cass to draft a contract. They would like that contract to be used statewide, and they'd like that contract to be used by our members. And so we're going to take that contract, we're going to publish it on our website under miscellaneous forms, and that will be out prior to the law going into effect. And so although it will not be an AAR form, we will have a form in place for our members to use when selling the mobile or manufactured home without the land being involved in the transaction.
And if I can jump in, this is Denise. I do with residential issues. I think that a lot of real estate agents aren't aware that mobile home park law is very complicated. And so when you're helping your buyer, you need to understand those laws, because the impact of those laws may substantially impact your buyer's ability to even live in that property, let alone enjoy what they thought they just bought. And so it's just really imperative that if you're going to have an agent that does that, that they take some mobile home park classes so that they understand what those laws are, what's allowed, what's not, what that process is, long-term leases, all of the things that are substantial issues to the person who's buying that and would impact the consideration they would pay. And as a buyer's agent, you have that responsibility to explain that to them.
Thanks, Denise. Let's talk marijuana.
Cool.
What can property managers charge for cleaning up the smell?
So hopefully all of you know that you are not required in the state of Arizona to allow medical marijuana to occur on a residential property. Even though the AMMA, the Arizona Medical Marijuana Act, specifically says that a landlord can't discriminate against a person with a medical marijuana card and use that as a sole reason to not rent to them, they don't have to allow the activity itself to occur on the property because of federal laws. So make sure that if you're doing property management that you specifically use a crime-free addendum, probably a separate addendum other than the AAR lease agreement that reminds the tenant that even though you see the little dancing marijuana leaf on the corner, doesn't mean you can use it in the property you just rented. This particular issue is treated just like any other nuisance. So if they were smoking, I'm presuming by the question that you mean the smoke smell of the marijuana, it's treated just like cigarette smoke smell. So any damage to the property you would be able to use, subject to the restriction that there's a prorated life of carpet and prorated life of paint, and so you'd have to deduct off the normal wear and tear and life of those products. So you may not be able to charge 100% of a new paint job if it has been painted in, say, 10 years. The residence hasn't been painted. So you'd still charge the exact same. I can tell you the bigger problem we've seen besides smoke is that if they're growing, and we've got properties around the state that actually can qualify to grow, and there's a substantial mold issue that is created, and it's a toxic mold that comes out of those grow facilities, and that can be very, very expensive. So we would still encourage the owners of rental property to not allow any grow station, even if it's allowed by state law.
Great, thanks. So Michelle, talking sub-agency, does that still exist in Arizona real estate relationships?
I was really surprised to see that as a question. You know, we talk about agency. Agency comes up as a topic it's very cyclical. It'll seem like, you know, for a while agency will be a huge hot topic, and then it kind of goes, you know, away. We don't talk about it very much, and then agency comes back. Arizona is one of the only states that doesn't have a specific agency law defining agency responsibilities of real estate professionals, real estate licensees, and I think that's primarily because AAR was very proactive in establishing the real estate agency disclosure and election form and all the disclosures that we have. So the question, sub-agency, is that still exist? Sure, it still exists. Sub-agency's been around since the beginning, you know, of organized real estate. And it can come up in a lot of contexts. Most of the time people think of that when, you know, back before buyer brokerages were, buyer brokers were so prevalent, which would have been like in the early 1990s. An agent would bring a buyer to another company's listing, and that agent, who the buyer generally thought was the buyer representative, was working on behalf of the listing agent and seller as a sub-agent. And that was the way real estate was done for years and years. Then the discussion about agency and fiduciary duties came up in 1990s. And those of you that might have been around and in real estate then probably remember that people talked about buyer agency, buyer brokerage like, you know, the sky was falling. It was a huge transition in the real estate industry. But in short, yes, sub-agency is still exists. I think some of Arizona's MLSs still give an option for the listing agent to authorize a co-broke fee to a sub-agent. When you look at the broker and agent relationship, that's really a sub-agency. I mean, so you see a sub-agency in other contexts other than with buyers and sellers. So I'm interested. So whoever submitted that question, shoot me an email. Let me know what you were thinking about, because I found that to be a very interesting question. So thanks for submitting it.
Scott, the field's getting a little crowded out there right now. How do agents protect themselves with the increasing number of new, untrained, possibly unsupervised agents in the marketplace?
Sure, I'll give you my thoughts on this. I'd like to hear everybody else's thoughts as well. Look, it's true. We have a large number of new licensees entering the profession every month. I learned recently from Commissioner Judy Lowe, that it's approximately 550 new individual licensees a month, which is a lot. But the educational requirements, the course load, none of that's changed. And so I wouldn't say that now it's any different than it's been in the past. And I certainly wouldn't say that there's a lot of untrained agents out there. But let's say you do encounter a new unexperienced agent who's in need of some guidance, agent in need of some guidance. I think it's incumbent on all of us to offer some assistance. And no, it's not your job to educate your fellow agents, but we hear all the time from our members that we want to raise the bar, right? We want to see the bar raised. We want to raise the bar in regard to the profession. Well, if that's truly the goal, I think we need to take the time to help these people out. Think back to when you were a new agent and how appreciative you were when a colleague took the time to offer you some guidance and maybe words of encouragement. It's easy to complain, but that's not what's going to make a difference. And so I guess I'd like to hear what you all think as well in regard to this topic, because it is something we hear about.
Yeah, this is Michelle. It absolutely is something that we hear about. We did a member survey about a month or so ago and asked what the top 3 business concerns were. And professionalism, education, unethical, agents was by and far the biggest concern that that agents responded on that survey. How can we address the problem? I think Scott hit it on the the nail on the head. We as an industry, you as an industry, have to take it on. Brokers. Large brokers generally have a mentoring program, so they bring a new agent on and generally have a mentorship program to educate them. But we have a lot of small or medium-sized brokerages that don't have that kind of mentoring service, and you also have agents that don't do a lot of transactions. It may be a part-time agent or doing occasional transactions. So I do believe that instead of being hostile to the situation, offering to assist that agent that may need some education, and to do it nicely without being accusatory is the best way that it can be handled, because I hear a lot of animosity between agents. You hear that a lot, and I don't think that that's healthy for our industry. And the animosity between agents, it's contagious, and it filters down to your clients, and they hear and see that as well. So I guess it's like, what is it, the kindergarten, just be nice.
Right, right.
And this is Jesi, if I can add, probably many people don't know, I was extremely fortunate to intern for Michelle Lind when she was still AAR's general counsel, and I would say that is one of the biggest aha moments that I achieved while interning for Michelle, that I really took away as a great lesson learned. And that was, anytime I heard Michelle give counsel, I was always amazed at her wise advice to not make it necessarily adversarial, because ultimately, if you do work together, your client does likely benefit. And really, I was always amazed at her great counsel regarding this very position. And from that, I know we often say best business practice, but that really came to my thinking, the forefront, thinking best business practice. How do we get this deal to go forward so that everybody is able to achieve the goal that they're looking for? But I love that is really something that she has always counseled, is not to necessarily make it so adversarial.
So maybe don't go on Facebook and blast the other agent publicly?
Probably not a good idea.
And if you really think it's a problem, this is Denise, I'm not really sure why you haven't reached out to that person first before you filed a complaint with somebody or told your client to go file a complaint with somebody. It just seems that it damages the reputation of all realtors when those go to the complaint level, when frequently a phone call to that agent first, or then if that doesn't go anywhere, then to their broker. And if you're the receiving broker, to hopefully handle that also as professionally as you can. Thank you for bringing that to my attention. Let me look into it. I think would be helpful just to our industry in general.
Yeah, and so as brokers, and thank you, Jesi. That was Jesi was a wonderful intern, and so we're so excited that she's now on the hotline and continuing that relationship. But so as brokers, I think it's incumbent on you to convey that message to your agents. You don't want to deal with these disputes, so you want to reduce them. So please consider, at your next office meeting or when you get together with your agents, bring it up as a topic and keep reminding them that we can all increase the professionalism of this business.
Great, thank you. So Jesi, there was a change in the short-term rental housing law for less than 30 days. Some agents are running into issues with HOAs that are still sticking with the 30-day rule. What should they do?
Right, so I do get this call on the hotline, and usually I remind folks that there is a statute, Arizona Revised Statute 9-500.39 regarding short-term rentals, and it provides a limitation on regulation of vacation rentals and short-term rentals, and it says a city or town may not prohibit vacation rentals or short-term rentals. However, it does not address what an HOA can provide in their CC&Rs. And so if an HOA has CC&Rs in place that prohibit short-term rentals, they have a requirement that rentals must be 30 days or longer, those still are legal. There is nothing in that statute that says an HOA cannot prohibit them in the CC&Rs.
Okay, thanks for the
Can I
clarification.
follow up with that? There was an omnibus bill passed a couple years ago. So if you're still having problems with the HOA, go look at some of the 2 omnibus bills that specifically said that an HOA cannot treat rentals differently in a number of circumstances. What they're allowed to ask for, copies of the lease, and also in that same set of omnibus bills, they said that the HOA cannot prohibit short-term vacation rentals unless it was in the original CC&Rs. So what that means, if there's 5 of us all that are owners, it may be original to me because I was an original owner. But if Jesi bought the property after I did and it was a CC&R at the time she bought it, she's going to be bound by that even if somebody else in the community can still do that. And so you still are having some issues with the HOAs and rental housing. Talk with legal counsel about those particular laws, and I think AAR has a good article about that on the website too.
Yeah, absolutely, and we worked hard on those HOA bills. Sue Fluke, who was our past president, was and does a lot of teaching with Denise, so is quite an advocate for that piece of legislation. But yes, it does, that provision does have to be in the declaration to be valid.
Great, thanks for the clarification. So Denise, how would you distinguish between a service animal and an emotional support animal?
That is a great question, and we hear it all the time. A service animal is a designation under ADA, and it's talking about an animal that is specifically trained to perform a service or a task, and that is a requirement in ADA situations, so restaurants, hotels, airplanes. There's a very specific set of laws about the animal has to be trained and identified, and the owner of that animal who is using it as a, say, guide dog may be required to produce some information about what the animal does. The rest of the animals, including emotional support animals, are what we call assistive animals, and those animals are what we talk about in housing. In housing, the animal doesn't have to be trained at all, which seems odd because you're going to get all kinds of certificates and a little jacket and all the things that talks about what their animal can do, and all of that is really ADA, not housing. The question for housing, which is for housing, is the person disabled under federal law? That's it. Is the person disabled? If the answer is yes, and there's no visible sign of what the disability is, we call it readily apparent, then the housing provider can ask the tenant or require the tenant to provide verification from a medical provider that the animal provides assistance performs a task or alleviates a symptom. That's the ESA, the emotional support animal. Well over 80% of all of our disabilities are not readily apparent. So a property manager can ask for that. How you ask and the format of what you ask is very, very complicated. So I would encourage you to use a standardized form that has been approved. Talk to your lawyer about that. We have one available on our website that specifically says what you can ask and what you can't ask. And when the tenant says you're not allowed to ask me, the answer is absolutely I can. And you should be doing it in a specific format so that everybody's clear about what they're asking for and what you're allowing.
Thanks. Excuse me. Michelle, has AAR ever considered offering data storage as service brokers?
You know, we're always looking for different different products or services that we can provide for our members. We really haven't looked at data storage servers here at AAR. And once I saw that question, I talked a little bit about it on what that would entail. We'd have to prepare our property for the possible demand, which could be very high. And so it would really become kind of a small business proposition. We'd need to set up another network, but we wouldn't have to do that here. We could do it at a colo location. So we would basically need the storage server, separate firewalls, another IP address, some backup equipment and software, and then agreements limiting what kind of data we could store, because we wouldn't want to be storing things like credit cards or other sensitive information. Because that adds another layer of liability and issues. And then also we'd have to deal with the bandwidth. So that's kind of just some of the issues that we would have to look at. We're always open to a service to our members. So if there are others out there that think that's something that you would like AAR to look into further to find out what the cost was, what the benefit would be for the membership. That's certainly something that I would be more than happy to take to leadership, and we would do an evaluation and determine whether it was feasible.
I was intrigued by this question because it was something that no one had ever approached me about before. I hadn't considered and I hadn't heard about. So I don't know what sort of demand is out there because it really was new, at least to me. And I think to you as well, Michelle.
Absolutely, yeah. It was another one of those questions where I was like, oh, that's a great question. I would never have thought of that. But yeah, I don't know what the demand would be. I know that we internally at AAR we have a lot of security here with our data here, and we also have a co-location, an off-site location for backup in case there was a fire or the server here was destroyed. So we've spent a lot of time on those issues, but never really thought of offering that service to our membership.
Thanks. We do offer a lot of benefits to you for things like you go for information on the broker quarterly, legal hotline articles, licensing classes for our CRMS and CRPM. So please do check that out. We are out of time for the day. Panel, I wanted to thank you very much for all your insights, and thank you to our viewers for joining us. Our next Broker Brief webinar will be on September 13th. So we hope to see you there, and have a great day.